In this video, I'm trying to explain a transaction for real estate. Any real estate transaction, I would divide this in two parts mainly. Sometimes you're dealing with sales and purchase a real estate, real property, and sometimes you're dealing with leasing or renting a property. So the main thing is you need to understand is if in the first part, if you want to deal with uh, real estate transaction in terms of buying or selling, there are two main steps. First step is basically if you are a buyer, then or you are a seller, you are going to deal with a realtor, and that realtor is the relationship between you and that realtor is um, it's a service contract. So by as per the regulation, there are some individual or some corporation, they're licensed to provide you service for selling or buying real properties. So the main thing for you should be the contract, the service contract. That service contract covering everything. Usually use template. There are a standard template they have to follow. So for you, the main thing is before dealing with any realtor or any broker, just check it out, see they are in a good standing, if there is any complaint against them or not. And those are the thing is the main thing you need to consider, because you might be a next person has an issue with them. So check everything, and the background check and everything, not too much, but somehow to secure yourself. So the first step is who's with you dealing, who representing you. That's the main thing. So that's the, as I said, is a service contract, and is a contract like any other type of contract. For a contract to be valid, there are some criteria, so some requirement about the subject, about the parties, about the consideration, and about the expiry, termination, and other things. So, as I said, because they are regulated, so they must follow some sort of template. But again, they can add additional things to their contract, so you need to be aware of that part. So, before dealing with any realtor, I would suggest if it's a big amount of investment or buying or selling a property, I think it's the best advice will be let someone check your contract, service contract. That's brokerage or listing contract or service contract, whatever is the contract you're signing with those brokers and realtors. It has to be. I would say you must go through it and then make sure nothing is wrong with that contract. So that's the first step. The second part is it's about the property itself. So let's assume you find a property, or there is a buyer for your property. That is the next level. In that level, there is a contract. So sales purchase contract. The sales purchase contract, if you're dealing through, sometimes people they decide not to use any representative. I would say don't do that. But if in case just you do it, then the best thing is at least having a lawyer to control and to check everything. But if you, in case you decided you have a representative, a seller, I mean a broker or realtors representing you, then they can prepare a sales purchase contract. The sales purchase contract is usually has a sunset. So the sales purchase contract is pushing you to the stage you can transfer the deed. I mean the title at the end of this process. So the once is the deal transferred, the title transferred, then this contract is not valid anymore. So the obligation, first part of the obligation for both party, buyer and seller, is a contractual obligation. So in part of contractual obligation, you have enough time to investigate more things before transferring the title or before paying for the real estate, for the real property. So that part has to be done very carefully, because in the contract, for example, if you want to have specific terms, if you want to say, I want to have this, I want to buy this and tear down and make some a new house, and that new house, you need to check it out if there is any restriction or any covenant inside inside the title, inside the deed. So those are things you can have it in a contract. If you don't put it in a contract, then you basically waived your fee or waived your right. So my point is, the contract is very critical for any real estate transaction, because as I said, you can eliminate your risk. You can add extra protection for yourself and many other things. So the sales purchase contract should just don't follow with the template, just don't follow with the standard terms. It sometimes happen, and then you're going to lose. The point is, for example, just I'm giving you an example. You are planning to buy a bungalow and then make it two-story or three-story houses, and then there is a restriction in that area. You cannot do it because of the zoning issue or some other type of issue. And if that's the issue, then you don't have it in a contract, or what's your intention is, what your condition is. When it's come to the closing date, you have to pay. There is no way you can waive. There is no way you can escape the contract, because it's valid and enforceable. So my point is, based on what you're planning to do for a real estate transaction, you need to know everything, and you need to have those terms inside your contract. And as I saw many things in my practice, and I saw many issues between sellers and buyers because of this kind of misunderstanding, or this kind of sometimes not disclosing enough information inside the contract. So a contract is very important. Some people say, okay, we don't need, because at the end there is a title transfer. If it's in Canada, there is a lawyer who can do the closing, or if it's in California, even you don't need a lawyer. It's title company, insurance company do the transfer for you. So my point is, where you should be more careful at the point of signing contract. That's the main thing. So you need to understand that point and add all information, all conditions, whatever you want, you're going to put it there. And then once you sign, so uh, the buyer, I mean the seller, has enough time until closing to get everything ready for title transfer. So, for example, there is a condition in your sales purchase agreement saying, I want to have a title free of any charge, any mortgage, any lien, and any other things. So the seller has time until closing date to fix that part. One of the major thing is, some people say there is a closing date, for example, that's set for August 26, 2025, and it didn't happen. So it's a breach of contract. Usually, it's not. In a real estate transaction, time is not essence. Time is not, I mean, there is a date, but that date, it's usually, you can go 30 days, even 2 months after for closing, for with some kind of justification. So it's not just, if you just pass the title, the closing date, and then as saying it was a breach, so I don't want to close it. Usually court is not in your favor in this part. So The closing date is not something you can just rely for breaching for your claim for breach of contract and asking for termination of the contract. Second thing is you need to understand is while you signing a contract, a sales purchase contract, if you are a buyer, you must get insurance. Why I'm saying this? Because if anything happened to that property during screw time, it's like a timing from signing the contract until the transferring the title. You must have insured yourself because that's your property under real estate law. It's your property. You don't have a legal title yet, but but based on a contract, you are the owner, so you taking the risk. So sometimes people saying, okay, I want to get insurance maybe like cheapest possible, cheapest rate possible. That's the mistake. That's the issue. You shouldn't do that. Why? Because again, it's your risk. If anything happened to that property, anything happened to that property, then you will lose. And you cannot say because this property is damaged or something happened to property, I'm not going to pay. So if you are a buyer getting insurance, it's one of the major things concern you need to address. You need to fix it. You need to get the insurance for the period of time before transferring the title. So that's the tip to you. And another thing is uh, when you sign a contract, inside the contract, you need to be careful about the type of warranty about the title. Um, there are different type of warranty. Sometimes some sort of warranty is just I'm warranting myself. I'm saying I am an owner and I'm selling it to you. That's one type of warranty. And another type of warranty says, I warranty, I am the owner, and before me also was an owner, and I warranty there was no defect in the title at all from me and from people before me. So that's another things you need to consider. So I saw sometimes contract, real estate contract, sales purchase contract, they have like a different type of warranty. You need to get the most covered warranty from the seller. So that's another thing you need to consider in terms of those sales purchase contract you're signing for. And again, once it's done, is at the closing time, then the title will transfer. You become a owner, officially owner as per the title, and legally entitled as owner. And then uh, the title transfer is different from one state another state in U.S. and also in Canada. You need to know what's the real estate law is the specifically requirement of land registering the registration is in your state or in your province. So you need to understand that point why you need to know, because the point is if there was somebody else before you, let's say they called someone who paid for the land for that property before you, and they, for example, they failed to register the lien, or they failed to do some other things, or transferring or registering their ownership or registering their interest, then will be some sort of issue. So again, as I said, uh, in terms of title transfer, that title transfer also based on what recording system has that state or province, it's different. So again, you need to ask a lawyer to explain to you what's going on here and how you can be protected. Sometimes real estate transaction seems fine, there is nothing wrong, everything good, you have a title, but when you dig in, you see, oh, there are some issue, there are covenant, there are some other interest never disclosed or other type of issue, then the best way is to protect yourself before closing and not after and going for a lawsuit or litigation after all. Anyhow, as you know, when you do real estate transaction, so basically you must pay. If you are a buyer or if you're a seller, you want to get paid. Uh, the money for that transaction, it can be cash. I mean, cash, which means not financing, which means it coming from the buyer own pocket, bank account, and but most of the time is not the case. Most of the time it's through mortgage or financing or loan. It gonna happen, especially these years through the recession, financial recession, and everything happening, especially in Canada. The issue is there are different type of lenders and financial institution you can finance through them, and each of them have different standard. You must be very careful if you are not dealing with banks. I mean public official banks, major banks. If you go dealing through private banks or you go through dealing with the private lenders, you need to be very careful about all pitfalls. Why? Because there are some regulation also regulating those kind of business and transaction, but because mainly is like a kind of business relationship between a lender and a borrower, so you need to be careful what type of the contract you're signing for, and is are the terms are complying with the regulation covering this kind of business activities. Anyhow, as I explained, when you finance the purchase money through any financial the organization, then there will be a mortgage situation. What's a mortgage? A mortgage is it's an interest. It's an interest. The lender, the bank, um, uh, registering their interest in your title, and they can give you money. And if you fail to pay as per the contract, there will be some consequences. And again, when you sign a mortgage, especially for example in the US, the situation is there is an interest registered in a property, that's a mortgage. Beside this, usually you sign also promissory note, which is enforceable against you personally, is not against the property. So these are different things. You need to understand. You need to understand sometimes you're going to lose also if, for example, something happened, the real estate, your home or your real property doesn't cover enough, doesn't have enough money to pay out the lender or they pay out the mortgagee. So that's the situation. Then they come after you for your personal asset, and that personal asset is based on a promissory note you sign. So again, you need to understand this point. When you transferring or assigning those property to somebody else other than selling, you need to be careful what you are exactly assigning. So if you fail, then there will be foreclosure, and then foreclosure is basically selling your property to get their money out, and there are process, and there are some way you can stop. For example, if there is something in terms of breach of contract, or there is some sort of fraud, misrepresentation, other issue, you need to consult a lawyer, real estate lawyer, can explain you what are the remedy you can say. You can maybe stop the foreclosure, or even after foreclosure, sometimes you have a right for wrongful foreclosure, you can ask for damages and remedies. So in this video, I try to explain you real estate, real estate transaction, real property transaction. uh, Most of the time is the most expensive investment you do in your life, and it's not just a simple thing. So you need to be careful, you need to understand all your right, and you need to understand the system, how it works, and you need to know if it goes wrong, what are your remedy available to you. If you have any more question, please call me. I'm here to help.